And welcome. Come on up, sir. Just a couple of announcements. Item number 2, AB 844 by Mr. Dickinson has been pulled by the author. And of course, that leaves us with 3 bills for the day. You may begin.
Thank you, Chair, members, and Secretary. It's a pleasure to see you again today. I've always enjoyed our conversations. So I'm pleased to present to you AB 1255. First, I'd like to offer amendments on page 4 of the committee analysis. These are technical changes received from the Secretary of State. So we'll be offering those amendments. AB 1255 will ensure that
They'll be accepted as author's amendments.
Yes.
Very good.
AB 1255 will ensure that California consumer cooperatives have the board of directors manage investment shares known as preferred non-voting shares. It's been my pleasure to work with the Sacramento Natural Foods Co-op and the Secretary of State on this important bill to promote job creation and healthy food options for consumers. We have almost every co-op in the state in support of this bill. One of these co-ops is the Davis Food Co-op, who is represented here by President Stacy Frerichs. I respectfully ask for an aye vote.
Good afternoon, Mr. Chairman and members. I'm Stacy Frerichs, the president of the board of the Davis Food Co-op, located in Davis, California. We are here to support AB 1255. The Davis Food Co-op is a full-line grocery store now in our 41st year as a community institution and consumer cooperative. The store we operate sells about $19 million in groceries each year and employs more than 140 people. We have over 11,000 shareholders, which translates to over 21,000 card-carrying members in a community of approximately 65,000 people. Together, our shareholders have invested almost $2.5 million in the one class of shares that we currently offer. Issuing preferred non-voting shares would provide another way for our members to support us. Because we would need to receive an affirmative vote from our shareholders to change our articles of incorporation and our bylaws, they would have a chance to ask questions, express views, and democratically shape our direction. Essentially, we would sell these additional shares to a member who knows our organization, who receives our membership shareholder information, who shops at our store, and who already has the $300 maximum in an equity investment in our organization. I'm available to answer any questions, and we respectfully ask for your aye vote.
Thank you very much. As soon as we established a quorum, we'll take up your bill for a vote.
All right. Thank you.
Thank you,
Mr.
very
Chair.
much. Do we have a quorum? We need one more. Sergeant, if you can please get one more member, please.
All right. So we're done.
Opposition? No opposition?
Hold on.
We do have opposition.
Mr. Chairman and members, I'm Michael Garabedi, and I'm a member of several food co-ops. There is membership concern about preferred shares that they be done in a way that does not harm the co-op. We're not opposed to the bill. We have brought our concerns to the attention of the author, and he has graciously pledged to work with us before this bill goes to the floor.
Thank you.
Thank you.
Others in opposition? Will the committee, as soon as we have a quorum, we'll move your bill. Thank you, Mr. Pan.
Thank you.
Okay.
Okay. All right. Thank you. Thank you very much. Right.
Huh? Mr. Dickinson, welcome. Come on up, sir.
Thank you, Mr. Chairman.
You may begin, sir.
Thank you. Mr. Chairman, members, I'm presenting AB 768 this afternoon, which updates and revises the Money Transmission Act, or MTA. The changes proposed in AB 786 are necessary to ensure that the MTA keeps up with growing technological innovation and that we provide regulatory certainty for existing and future licensees. There are a number of major provisions of the bill in light of the time, the day, and the hour. Unless the committee wishes, I'm not going to enumerate those. They are covered quite nicely in the analysis. So let me just say that that these changes that are proposed in the bill came about after the Assembly Banking and Finance Committee conducted an oversight hearing of the MTA earlier this year, in addition to a host of conversations with various stakeholders. Money transmission has expanded drastically beyond international remittance activity. Now, mobile payment operations are changing the way in which consumers move money from A to B or pay for goods and services. The payments technology is a highly competitive and rapidly expanding industry. The broad application of the MTA could have a detrimental effect on innovation by stifling new payment systems and networks that are being introduced by a growing list of California-based startup companies. AB 786 attempts to find the right balance in correcting several technical issues for existing licensees and also makes the licensing process more transparent. This is a balance between consumer protection and allowing desirable innovation and creativity and movement of money. There are some witnesses here in support, and I would respectfully request an aye vote.
Witnesses in support, please.
Mr. Chair, members of the committee, Greg Hines with Hines Government Relations here on behalf of eBay and their business unit PayPal in strong support of the measure. I have with me today Mr. David London, the Senior Director for U.S. Government Relations for eBay, who will elaborate on that position. Thank you.
Great. Thank you, Mr. Chairman. As Greg said, my name is David London, Senior Director for U.S. Government Relations at eBay, Inc., and I am in strong support of AB 786 by Assemblymember Dickinson. As you may know, eBay Inc.'s PayPal subsidiary has been a licensed money transmitter in California since 2002. We have over 6 million active registered users in the state.
Please excuse me for a minute. We're going to establish a quorum. Please call the roll.
Correa,
Here.
Berryhill, Bell, Calderon, Hill, Wessel, Roth, Torres, Walters.
You may continue, please.
Thank you, sir. So we have over 6 million active registered users in the state of California, and we are a proud resident of the 15th Senate District. At PayPal, we are passionate about maintaining robust regulatory compliance while also ensuring that consumers using our services and products can do so knowing that our systems are secure, that their financial information will not be compromised, and they will be made whole in the event of fraud. To that end, we maintain money transmission licenses in states in which we operate. And as a company, we know that you cannot maintain consumer trust and confidence in the financial services without absent regulation. And that is why we are here to support the assurances that the Money Transmission Act affords to our customers. With that in mind, let me explain why, very, very briefly, why I'm here this afternoon and why we are such strong proponents of AB 786. As you know, in 2010, the legislature reformed and modernized the California Money Transmission Act. However, the focus was almost exclusively on traditional money transmission services and neglected the world of high-tech payment companies like PayPal and our peers in Silicon Valley. Assemblymember Dickinson noticed this oversight when reports began surfacing last year about the challenges facing many high-tech startups who were trying to obtain licensure in the state. He approached us to see if we had similar experiences with the Reformed Act and thus began a conversation about how to guarantee that companies trying to use and try to bring novel payment solutions and technologies to market in California could do so in a way that was clear, predictable, consistent, and didn't erode consumer protections that have already been enshrined in the Act. Now, not every amendment in the Act is a material benefit to PayPal, but we do believe that Assemblymember Dickinson's goals are laudable and that he deserves to be commended for taking on this issue. PayPal is supporting several measures in this bill, and without going into detail on each of those provisions, I would just call to your attention one particular section, which is Section 6 of the bill, related to the requirements to maintain eligible securities.
Others in support.
I ask for your, thank you for your time, Mr. Chairman.
Okay. Mr. Chair, members, Shane Levine on behalf of the National Payroll Reporting Consortium. We represent the 12 largest payroll providers in the country, which encompass about 40% of the employees in the state of California. We are in support of the bill and thank Chairman Dickinson's efforts with us and working with us and the members and staff. Our position is that this bill currently in print conforms with the original intent and spirit of AB 2789, the original implementing legislation of the Money Transmission Act. The legislative history, analysis, and committee hearings that we pulled and watched were all replete with references to consumer retail transactions, not broader business-to-business transactions. As amended, we would be regulated and be required to get a license for any activity where we do interface with consumers in consumer retail transactions such as payroll cards, and not for broader business-to-business transactions. So in short, we do support the bill, and with that and those reasons, we'd ask for your aye vote. Thank you.
Mr. Chair, Robert Callahan with the Technology Association of America. Also in support, we do believe it promotes regulatory certainty and innovation in the MTA. So ask for an aye vote.
Others in support? Opposition?
Good afternoon, Mr. Chairman and the committee. My name is Aaron Greenspan. I'm here representing Think Computer Corporation. We're a startup in Palo Alto that works on mobile payments, or at least we used to. I'm here to stress as much as I can that the Money Transmission Act and AB 2789 that created it and AB 786 are really a pretty outrageous sham, and I think it's possible to lose the forest for the trees here. AB 2079 came about because 4 or 5 large money transmission companies wanted to protect their own interests at the expense of the California public and the public nationwide, because California plays such an enormous role in interstate commerce. There's an exemption in AB 786 for the payroll industry, but not for lawyers, not for the companies that process all of your political donations, not for private universities like Stanford, not for FedEx, UPS, and DHL that routinely transmit money by hand, not for retail payment processors, and not for startups that must hold money to do business like mine. There's also no substantive reason why the numbers in AB 76 are actually there. I think the old statutory requirement for net worth was $500,000. It's now being dropped down to $250,000, but there's no rationale for that number. My company is already suing in court the Department of, I guess it's now Business Oversight, because the DFI is no longer with us. It's been merged. And the reason for that lawsuit is that this bill is so broad, it effectively regulates every aspect of commerce. And I think you need to ask yourselves, is that something that you really want to do? Because while consumer protection is a legitimate interest of this body, I don't think consumer protection is actually achieved by regulating everything under the sun. I think the way that we can protect consumers is by encouraging technologies like PayPal, which would not exist today if this bill were in place 10 years ago or 15 years ago. The way to protect consumers is to create new technologies, such as the one that my company did, which now has a patent, that reduce fraud and reduce prices. The only people being protected here are the CEOs of Western Union, American Express, MoneyGram, and TravelX, which are the companies that lobbied for this bill in the first place. And of course, you're going to get the payroll companies, which aren't going to be exempt, and you're going to get eBay, which is going to protect its own interests in support. But that doesn't leave much for the public. And frankly, I'm the only one here representing the public because no one else knows what to do about it. There are draconian measures if you violate these laws. It's a violation of federal law 18 U.S.C. 1960 to violate any state money transmission statute in any way. And the DFI, which claims to be, or now DBO, sorry, DBO is claiming to protect consumers, but meanwhile they refuse to post, in violation of Financial Code Section 583, any of their final orders on their website, as they're required to do. So the public can't even see what they're doing to supposedly protect them. I personally feel this is all outrageous. It's completely destroyed my life. I had to fire all my employees. It's obviously very personal for me, but I don't want you to think that this is just a personal beef. There are real constitutional issues here. This is an interstate problem. It needs to actually be solved by Congress, because when it comes to interstate commerce, and especially mobile payments, there's just nothing the states can do. You can't even tell if I make a mobile payment, am I in California or am I in Kansas, where Sprint has its headquarters? Or am I going to be regulated by the state where I'm physically present? Or what states does that payment go through to get from server to server. There are all kinds of technological questions which this bill just cannot keep up with. And I again encourage you to ask serious questions about whether this is the right course of action or whether this entire law should be repealed and Congress allowed to actually regulate this in an intelligent way. Thank you.
Thank you. Others in opposition?
Thank you. Good afternoon. My name is Tim Marvin, and I'm representing Consumers Union, the policy and advocacy arm of Consumer Reports. I'm appearing today on behalf of my colleague who was unfortunately called away to a family emergency and couldn't be here today. We are opposed to the bill unless it is amended. The committee analysis correctly outlines the rationale of our opposition. We believe that the primary focus and function of California's Money Transmission Act is consumer protection. We would like to see the bill amended to delete the broad exemption language for payroll processors. We are also opposed to decreased net worth requirements. We are willing to continue to work with the authors to address these concerns. Thank you very much, and if you have any questions for us, I'm not the guy. Thanks.
Others in opposition? Questions from the committee? Will of the committee? Questions, sir?
Mr. Chairman, let me ask a question. So remember, law firms were mentioned. Does this cover law firms? For example, if a law firm takes in money, normally it would be into a trust fund.
Right.
On behalf of a client for distribution to someone else. I haven't looked. That would appear to be the transmission of money.
Right.
Would that require the law firm to be licensed?
No. No, and to the best of my knowledge, DFI up to this point has not considered lawyers' trust funds to constitute money transmission. I think by common sense understanding of what money transmission is, it would not encompass lawyers' trust funds, and this bill does not mandate that lawyers' trust funds be covered. But I think there is a larger issue here, and I don't want to take a lot of time with, but I do want to raise so that we're all aware of it, and that is defining what constitutes money transmission is difficult. And the original legislation defines it in a circular manner. It essentially says money transmission is money transmission. So what we're trying to do in this legislation is give a greater degree of clarity to what constitutes money transmission and to what activities it applies. That may still need to evolve some. I would candidly admit that, and we're continuing to have that conversation, but it would not cover lawyers' trust funds.
And to the extent there is an issue, you'll clear that up as we take this along.
We are continuing to have that conversation with stakeholders and internally about how best to define it, yes.
Thank you very much, sir. Thank you, Mr. Chair.
Other questions of the committee? Will of the committee?
No, I just wanted to mention that bill has been moved.
Thank you very much. Seeing no further questions in the committee, please call the roll. Do you have a motion? Do pass.
Motion is due pass. Correa?
Aye.
Correa, aye. Berryhill? Berryhill, aye. Bell? Bell, aye. Calderon? Hill? Hill, aye. Wessel? Wessel, aye. Roth? Roth, aye. Torres? Walters?
6-1, that has plenty of votes to move on.
Thank you, Mr. Chairman.
Let's take up AB 1255 for if somebody would like to motion on that bill.
Motion is due pass as amended.
The motion would be due pass as amended.
Yes. Correa?
Aye.
Correa, aye. Berryhill? Berryhill, aye. Bell? Bell, aye. Calderon? Hill? Hill, aye. Wessel? Wessel, aye. Roth? Aye. Torres? Walters?
6-1. That measure also has enough votes to move ahead. We'll place it on call for others that might want to add on. Mr. Frazier, welcome. You have one item, AB 1162.
Good afternoon, Mr. Chair and committee members. First, I'd like to start by why I'm not accepting the committee's amendments. We'll start with the ATMs. AB 1162 has stronger language regarding the amount of ATMs that should be available to students on campus. The amendments strike this language and substantially weaken the bill by only looking at the number of ATMs and their distance from the campus versus AB 1162's language, which requires at least one fee-free ATM on every campus and satellite campus, as well as additional ATMs based on student population. Currently, there is an insufficient amount of ATMs on campuses for students to access their financial aid money. Go on to fees. AB 1162 suggests prohibiting certain excessive fees that have been consistently problematic for students. The amendments strike this prohibition and only requires colleges to look at the types and size of fees that students will incur. Below are examples of the fees that I am going to identify. Account balance inquiry fees up to $5 per inquiry, 50 cents per transaction fees, inactivity account fees up to $10, replacement card fees up to $20, transfer or wire fees up to $25, dispute fees up to $25, and we have account closure fees and insufficient fund fees at the automated teller machines or point of sale. And then we come to the issue of co-branding. AB 1162 suggests prohibiting co-branding on debit cards. The amendments strike this language and replace it with language that assumes that there's no impact on students with regards to co-branding. The impacts, if any, co-branded card, when in fact co-branding gives students the implied endorsement from the school as the preferred bank to sign up with. Also, the amendments suggest disclosing that the co-branded card is not endorsed by the college. When the college has chosen a bank to disperse financial aid onto debit cards, and then they put their mascot on the card, and that is an endorsement in itself. But I wanted to clarify our reasonings for not wanting to take the committee amendments. But I wanted to start by thanking the committee for taking such an interest in this important piece of legislation. AB 1162 is a very simple bill that asks college boards to adopt policies that best serve the needs of students. Colleges and universities have begun to outsource their financial aid distribution to third-party contractors like banks and other financial institutions. While these partnerships may be beneficial to the school, students have suffered financially as a result of these lucrative contracts. My bill gives college boards the power to negotiate a number of items that students have consistently had significant issues with when dealing with third-party contractors. The first issue is providing students a clear choice of the way they can receive their financial aid. I applaud Senator Calderon because your bill addresses this issue directly by prohibiting colleges from entering into a contract with a third party that requires a student to open an account to receive their financial aid. The second issue is the number of ATMs on campus. Under federal law, third-party contractors are only required to provide one ATM on campus with no regard to the size of the college. So if you could imagine only one ATM to serve a college with a population of 30,000 students, the lines are often long, the ATM often runs out of money, or the ATM breaks down. Students are then literally forced to go to a foreign ATM and suffer up to a $5 charge in fees to withdraw their financial aid. The third issue is the high fees students have had to deal with in the past, particularly the PIN number-based fee. When someone goes to pay for their goods with a card, they are usually given two options, debit or credit. If you choose debit, you put in your 4-digit PIN, and if you choose credit, you sign. Although these cards are debit cards and have debit printed on them, a student is charged a 50-cent PIN-based fee when they choose the debit option. Students also had trouble with inactivity fees. A student that makes the choice not to use the card can be charged a $10 inactivity fee. Students also have had trouble with account balanced inquiry fees. When a student is trying to be a good bank account holder by checking their account balance to see if they have sufficient funds, they are charged a fee. Also, if a student attempts to close their account, they are charged an account closure fee. So students are charged fees when they use the card, when they don't use the card, and when they try to be responsible, and when they are sick of the card and try to close the account. The fourth issue is having an adequate amount of disclosure of the terms and conditions and fee structures. Having the students be financially responsible is a crucial part of growing up. But a student must be able to access terms and conditions and fee structures information in order to become financially literate. The fifth issue is the co-branding of the debit card with logo or mascot. Co-branding these cards gives a student an implied endorsement from the college or university that the third-party contractor is the preferred bank that the college has chosen for the students. Sixth issue is of mandatory arbitration. By no means is my bill prohibiting arbitration. As a business owner, I believe arbitration can be a quick and easy process, but I also understand that arbitration is meant to be voluntary. In voluntary arbitration, both sides in the dispute voluntarily agree to submit their disagreement to arbitration after it arises. But in enforced or mandatory arbitration, a company requires a consumer to agree to submit any dispute that may arise in arbitration. The individual is required to waive that right to sue, to participate in class action lawsuits, or to appeal. Forced or mandatory arbitration severely limits consumer options for resolving a dispute. Before many problems arise, you lock yourself into one option, binding arbitration, for resolving all future disputes or problems. As you've heard, students have had a number of problems with these third-party contractors, and on page 10 of the analysis, the list of supporters is ever-ending for this bill. The Community College League, which represents all 72 community college districts in the state of California, are supporting this bill. The California State University Office of the Chancellor supports this bill. Students, group from the community colleges, the CSUs, and the UCs are all in strong support of this bill. Even in your district, Senator Correa, the Chancellor of Rancho Santiago Community College District, Raul Rodriguez, and the President of Santa Ana College, Erlinda Martinez, both support this bill. Now look at the opposition to this bill. The California Bankers Association claims that this bill is preempted by the National Bank Act. For those of you who weren't in the Senate Education Committee 2 weeks ago, we had an official statement from Legislative Counsel stating that our bill is not preempted by the National Bank Act. The Civil Justice Association of California is opposed to the bill because they claim that it is preemptive of the Federal Arbitration Act, which is also disproven by Leg Counsel in the Senate Education Committee. Hire One, which is one of the first and most widely used companies, will claim that the business was created by college students to provide a service. While that is great in theory, there is little or no federal regulation that ensure that a student's financial aid, which are taxpayers' dollars, are protected from this third-party contractor. AB 1162 will ensure that students are protected and their best interests are in mind when the college negotiates these contracts with a third-party vendor. We would all like to protect the students and ensure their financial aid money is secure and used for their education. And I respectfully ask for your aye vote. But with me here today is Lori Nazura from the California Student Aid Commission, Emily Kinner from the Student Senate for the California Community Colleges, and Garo Manikin from CalPRIC.
Before the supporters talk, since you called me out and you talked about the amendments, let me respond a little bit, sir, if I may.
Sure.
You and I have spoken about this bill many, many times, and both of us agree that the best interests of the student have to be placed first and foremost. Not should, but must be placed first and foremost. We also agree that full disclosure, clear and full disclosure, should be given to all students. We agree, yet I'm kind of a little bit at a loss here that we can't agree on your bill. First time we spoke, you said you didn't want students to have to click through a number of pages on the internet to figure out what the fee schedules would be. You wanted card fee schedules to be readily accessible from the home page and at a financial institution's website as well. You also wanted students to understand that the presence of a school name or mascot on a card didn't represent an endorsement. And you said you wanted schools to understand that they should negotiate with financial institutions on issues of fees and dispute resolutions. With all due respect, your bill does not achieve those goals. I'd support your bill if you'd accept these amendments, because these amendments do exactly what you want. The amendments require school policies to ensure that contracts between schools and financial institutions disclose the nature and amount of all fees associated with cards use in a clear in conspicuous manner before students consent to receiving those cards. The amendments also require school policies to ensure that a printable version of the fee schedules can be accessed from the homepage and can actually be printed out. The amendments also require the school policies to disclose to any students that is offered the card, which includes the name of the mascot of a school, that these co-branding do not represent an endorsement by that school. And finally, the amendments make it clear that schools should consider several factors when negotiating these contracts: number of ATMs, the distance from campus of other ATMs, the types and size of fees that may be incurred by the students when they use the cards, the impacts of a decision to offer co-branding of a card, and the impact of the mechanism used to resolve the disputes. These amendments essentially do what your bill wants. Support.
Thank you, Chair Correa and members. Lori Najura from the California Student Aid Commission in support of AB 1162 by Assemblymember Frazier. The Commission and state have a huge stake in this discussion. We administer $1.7 billion worth of financial aid to over 255,000 California students that could potentially end up on these debit cards. The Commission carefully collects and monitors each Cal Grant campus's policies on financial aid disbursement, refunds, and over awards. And we're very interested, of course, in the policies that are listed here in Assemblymember Frazier's bill. As this bill is currently written, the schools are encouraged to consider whether to prohibit certain fees within their financial aid disbursement contracts or not. Now, I know you have seen a legal opinion that says that that provision preempts federal law, and you've also seen your own Ledge Council's opinion that says that it does not preempt federal law. I'm not here to speak about the legal issue, but to show you the actual practices that the Commission staff have noticed ourselves in exploring a lot of these contracts. We've looked at over 30 contracts for financial aid debit cards. For example, Hire One, very prevalent among the community colleges, as the Assembly member said, charges a 50-cent fee per PIN-based transaction. I'm just going to kind of focus on that particular fee. Sallie Mae, which is used by Cañada and Riverside City colleges, does not charge a PIN-based fee at all. U.S. Bank, which is used by several CSUs, including CSU Fullerton, allows 4 fee-free PIN-based transactions per monthly billing cycle. It's possible that credit unions could develop agreements with local campuses. I know my credit union doesn't charge me a PIN-based transaction fee, so why shouldn't a school consider this and other fees and whether or not to allow them for their students when negotiating contracts for financial aid disbursement? I do my shopping every Saturday. I'm a creature of habit. I go to 4 different markets every weekend, and I plunk down my debit card. If I was using one of these debit cards, I would incur $2 per week in fees. Now let's take the same for a low-income student who, in addition to that, also needs to use the bus or other public transportation to get to their campus. That $2 per week may be bus fare for an entire day of classes that week. Should our students have to choose between buying food or attending classes when budgeting out their financial aid dollars? The contracts that we've seen so far do not address student fees. They're not in there because the contracts are between the contractor and the school. So they deal with the charges between the contractor and the school. The fees are between the contractor and the student, so we have no evidence that those have been considered during the negotiation of these contracts. We can't see it. We don't know where it has occurred in the process.
Can I interrupt you very quick?
Yes, sir.
Your comments, they were addressing The main bill or the amendments? Because they
The main
sounded they
bill.
could have addressed either one.
The main bill, the listing out of the prohibition of certain fees.
Thank you.
Thank you for asking me to clarify. And it's for those reasons that actually Assemblymember Frazier's bill, as listed, is so important, because the schools need to be aware that they have an opportunity to negotiate whether or not those fees even exist within the contracts that they negotiate. So the Commission asks for your support of Assembly Bill 1162 today and these provisions for student protections and student choice. Thank you.
Others in support?
Good afternoon, Mr. Chair and members of the committee. My name is Emily Kinner. I am a student at the Foothill De Anza Community College District. I'm also a student senator with Region 4, which represents Bay Area schools, including Fremont and Santa Cruz. And we are here to support this bill. While we appreciate the bridge of services that campus debit cards provide to deliver financial aid funds, I'm here representing 2.5 million community college students to ask you to support this bill, which asks districts and campuses to implement best practices to protect our students. As you've already heard, students are charged to activate their cards. Students are charged not to use their cards. Fees for inactivity, activity, replacing the card. Students are charged every time they use it as a debit. And students are even charged for withdrawing money out of an ATM that is not campus-based, and they're charged to even find out how much money they have in their account. We are concerned about the charges that students are being charged without proper disclosure on websites. We've had hundreds of students come to our Student Senate concerned about these charges, asking for assistance on what to do. We think this bill addresses a lot of those concerns in just encouraging districts when they are negotiating contracts to consider not charging these fees. And as you've heard, there are some districts that have made the choice not to implement some of these fees. The financial aid dollars on these cards are distributed to our neediest students, which are our Pell Grant students, our Cal Grant students, students that have student loans and BOG fee waivers. We want students to use their financial aid dollars to go to the cost of attendance. And we want students to have choice in where to best spend their precious financial aid dollars on how to afford colleges. We ask for your support on this bill that asks for contract negotiations to consider the impact of these fees on our students before agreeing to terms that further prohibit our neediest students from affording college. Thank you.
Good afternoon, Mr. Chairman, members. My name is Garo Manjikian. I'm the legislative advocate for CalPIRG, the California Public Interest Research Group. We released a national report on this issue last year called the Campus Debit Card Trap, which has been shared with your offices, and I wanted to share with you some of the findings in there, and I apologize if I repeat. So almost 900 of the 7,300 campuses participating in the federal financial aid program now have banking partnerships, and that includes 32 of the largest public four-year universities, 26 of the largest 50 community colleges, and 6 of the largest 20 non-for-profit schools that have these contracts. And as mentioned, unfortunately, these partnerships come at a price for students. We found that first, many banks charged a lot of fees. There's a per swipe fee, a PIN fee, an activity fee, and overdraft fees. The second, as mentioned, not enough ATMs on campus. And the third was the aggressive marketing strategies that led students to believe that they didn't have a choice on where to bank. I just want to say that the most impacted students are among the neediest. Students most reliant on financial aid come from low to moderate income backgrounds. So it's roughly 40% of freshmen are first-generation college students, and 25% of all students are both first-generation and low income. So we need to make sure that when these contracts are negotiated, there are strong consumer protections in place. And AB 1162 does just that by requiring the colleges and universities, when negotiating a contract, the policies should best serve the needs of the students. And we like that it provides the best practices as well for them to use and consider. And also, as mentioned, this is also about protecting financial aid. We believe that every dollar of financial aid should be going to a student's education, not to bank fees. And so we urge every member of this committee to vote yes on the bill. Thank you.
Others in support? Can you please identify yourselves for the records?
Good afternoon, committee members. My name is Daniel Thomas Clark. I am from Fresno State University. I am a student at the school, and I am also part of the Associated Students Incorporated. I'm here on behalf of CSU Fresno, who are, like myself, are heavily taxed by this same card right here. CSU Fresno is the only school in the CSU system that has a contract with Hire One to disperse our financial aid money. It sure does. That's our mascot. Would you like to see it, sir? I'd be more than happy to hand it to you.
I don't want to see anything from Fresno State. I'm from San Jose State.
We have a Spartan in the room. I'm sorry about that.
We're going to take you on, San Jose.
But we are heavily taxed by this company when the school enters in business with this company, and we're also taxed in the form of fees. Our financial aid and our Cal Grant dollars are being dispersed onto this card and is being taken away, given to this company. I'm here hoping that the committee supports this measure and to ensure that my fellow students in the community college system, the CSU, and the UC system.
Let me ask you, have you talked to the locals at your university about this issue?
Yes, I have.
What's their answer?
There is a lot of anger about it. There's a lot of frustration.
No, I'm talking about the administration at your school. Have you addressed this issue with them?
I myself personally have not. However, the CSU Associated Student Incorporated body has.
And what's the response from your president of Fresno State?
We have an outgoing president and we have an incoming president at the moment.
So the outgoing president, why did they enter into this contract? Would you know?
I don't have the information, but I'm more than happy to provide it for you when I get it.
Let me ask, when you get your debit card, that's what you use, correct?
Correct.
Can you take that and open up a bank account with it and put the balance into a bank account to another bank?
I can, but I'll get charged for it.
One time or many times?
Depends on how many transactions I'm going to.
If you take your full amount of your debit card and you put it to a checking account, how many times would you get charged for that?
If it's a one-time thing, I take all my money and put it onto a Citibank or a Wells Fargo, I'm going to get charged for it. How much? I can look it up for you if you'd like.
Please.
I do. We rarely use it.
Is it a one-time transaction or?
If I decide to take all my money from the Hire One card and put it onto my banking account, there will be a fee associated with that. I believe it's $25, $38.
Anybody can answer that question? I'd like to have the answer to that question. You believe, but I really want to make sure we get the answer to the question.
I have a listing
I'll let
right
you
here.
go ahead and finish because I want to get through everybody. We're losing members real fast here, so I want to make sure we get all the testimony in.
Good afternoon. My name is Chuck Stevens. I'm with the Student Senate for California Community Colleges and a student at San Jose City College. One thing I would like to bring up is that I can, for my Hire One card, I can act to put my money in my B of A account through direct deposit. That's not an issue. The problem is that it takes 3 to 5 business days. And so if a financial aid is released on a Thursday or Friday, I have to wait that X amount of time to actually see it in my account. And being a banker myself, I used to work for Safe Credit Union. Direct deposit goes through in an instant. There's no reason why it should take 3 to 5 business days to do so. So we humbly support this bill. Thank you very much.
And by the way, the Calderon bill addresses that issue. Go ahead, sir.
Good afternoon, Mr. Chair and members. I'd like to thank you for the opportunity to speak. My name is Robert Frazier. I'm a senior at Sacramento State, and I'm also here with the California State Student Association. As a student, it's troubling to see students' financial aid money going for what seems like very pointless fees like per swipe and incorrect PIN and things like that when students should be able to use their financial aid money for their education. So for these reasons like that, we do ask for your support.
Did you at your school talk to the president of the state
that's
university
an issue
to ask
Sacramento State,
why they entered into that contract?
Sacramento State does not have a contract with a financial institution for
so
that.
Who do they have a contract with?
We don't. I'm here in support of my fellow CSU campuses.
Oh, so
Fresno is the only.
Does that not affect you directly then?
No, it does not.
Okay.
Yeah. But I do ask for your support for this bill.
Thank you very much. Others in support?
Hello, my name is Sita Rimrao, and I'm here representing California State Student Association, and we ask for your support on this bill because it does affect students, and whether or not I'm at the Fresno State campus, it does affect students, and I represent all CSU students.
Thank you very much. Others in support?
Hi, Chairman, committee members. My name is Miriam Sadama. I am the Associate Students Incorporated president at CSU Stanislaus, and also on behalf of the California State Student Association. I am in support of this bill, and hopefully we'll get your guys' support. And I also support all the arguments that was taking in place. Thank you.
Others in support?
My name is Amber Demi, and I'm here representing California State University Stanislaus as the Governmental Affairs Administrator. And I'm also here with California State Students Association, and we would like to request your aye vote on this bill. Thank you.
Others in support?
Thank you, and thank you for hearing all this testimony. My name is Rich Copenhagen. I am the outgoing president of the Student Senate for California Community Colleges, representing the 2.5 million students of the system. And I'm here to express my very strong support for this bill, which will lead us back towards teaching our students to trust our institutions and to trust banking and financial institutions. Right now, I come from the Peralta Community College District, and I actually sat on the Board of Trustees as a student trustee when my district entered a contract with Hire One, and I was told there were no fees and no problem with it, and we've been fighting ever since to get our district to reconsider their decision to...
So your district told you they entered into a contract with no fees and there were fees?
So what I was told...
Is that what you're saying happened?
That is correct. Okay. Thank you.
So do you think the attorneys of the district didn't read the contract, or did they not fully disclose to you what was going on?
I would lean towards the latter, but I don't know what was going through their heads at the time.
Thank you very much. And by the way, I wouldn't trust any institution. You don't learn through legislation to trust any institution with your money. I think that's the one thing you need to learn, sir, that you've got to check each and every transaction. And that's why people jump from bank to bank, because, well, thank you very much.
Thank you.
Alpha Banks, I'm sure they do that as well.
Teresa Tena with the Community College League of California. We are in support of this bill. Our trustee board, our CEO board took a support position primarily focused on the concerns that have been raised, particularly in this analysis related to some of the practices, and thought that it was a step in the right direction to encourage straightforward policies in the entering into these types of contracts.
So let me ask you, why would these colleges and universities enter into these contracts in the first place?
Well, for one...
At the expense of the students?
No, in the best interest of the students. I mean, for one, I think this is certainly...
Well, why then would they agree to these fee schedules when they enter into these contracts?
Well, I think, this is certainly a mechanism to make easier the disbursement of financial aid, to reduce the administrative costs for the districts. And
administrative costs to whom?
For the institutions.
Okay, the financial aid.
Financial aid administrative costs in terms of the disbursement of the dollars out, and to just devote some of those resources which previously were used to administer the disbursement to instruction or any other area of the campus that could certainly use those. And so, this we saw as a best practice policy, and we're supportive of this bill for that purpose.
Thank you very much. Others in support?
Mr. Chair,
we have a question for Mr.
point.
Hold on a second, ma'am. You're very popular today. Mr. Roth.
I have to get some clarity here. I'm not an expert on this. So are these banking relationships required on the part of the colleges, community colleges, and CSUs?
No, they're not required. And I speak on behalf of the community colleges. They're not a requirement. But our institutions have realized that there is quite a bit of expense oftentimes with distributing and handling the financial aid disbursement. And so these are looked to as a means to reduce the costs of administering those.
So there's probably an expense on the other side of the people issuing these cards, I would assume, right?
In terms of the institutions issuing the cards?
Right, the financial institutions.
I would think.
So what's the alternative if we don't use these debit cards for students?
Students already have the alternative to opt out and to receive a check. And so, that's certainly a little bit more cumbersome of a process in terms of cutting checks. Occasionally, some of our institutions actually have to have their checks authorized through the local county Office of Education. It depends upon, what particular institution is at hand in that instance.
So we've got a bureaucratic problem in terms of getting the money efficiently and effectively into the students' hands so they can use it within our college and community college system.
Certainly, and that's one of the reasons why the colleges have entered into these types of arrangements. Not all of our colleges utilize this as a means to distribute out financial aid.
So how long does it, and is the average in the community college system, how long does it take to get a financial aid check to a student?
Well, it depends. I mean, there's quite a bit of processes involved. I mean, I used to work in a financial aid office at a local district, and so you've got to wait for the federal government to disperse the dollars, realize that they're in your account, and then of course you've got to do a check run, and you only do that once you get information from your financial aid administration folks as to who's authorized to receive a check, and then it is a bit of a cumbersome process because you have to have students come in to actually receive the check identification, make sure it's going out to the appropriate individual. So it is a bit cumbersome.
But that's the point where the card would start, right? Because you're not going to transfer money onto a student's debit card until the feds issue the money. You get the money, it's verified by the financial aid office, and they verify it goes to student A. And at that point, the money goes to the debit card, right?
Correct.
So from that point on, how long does it generally take to get the check to the student who opts out of the debit card arrangement?
I'm not sure. I mean, from my experience, I'm not sure how many days. I mean, if you're looking for a specific, I'd have to get back to you on that. I don't know. Under the arrangements now in different institutions, if they have the card, if the student opts out, I don't know how much of a problem or a bump that would cause in the disbursement if, say, the majority of students are receiving their dollars versus on the debit card, and then on some of them opt out. I don't know what that would be. I'd have to get back with you on that.
But again, these debit cards are an opt-in or an opt-out issue for the student. So, to follow up on the chair's question, and why haven't the colleges, the CSUs and the community colleges just done this on their own, as opposed to require the bill that requires, and I'll get to that in a second, but appears to require financial institutions to issue no-cost cards, position ATMs on. Why haven't the community colleges and why haven't the CSUs negotiated these contracts, assuming you can get contracts, that provide no-fee cards, multiple ATMs, convenient access, and all the other things that are contained in this bill?
Well, I think there's definitely, you'll hear from the banking folks, but I think there's certainly expenses attached to, utilizing those services. And, from our institution's perspective, we're trying to put forward a mechanism that is both, seamless and easier for the students to utilize, but also, engage and hope to have continued engagement with the banking institutions to facilitate that process. So, I think we do strive for that, and we certainly strive to have the students at the forefront in those decisions. I know of one institution, West Valley Mission, that had a survey done to query their students in terms of their satisfaction with the debit cards, and overwhelmingly they were very satisfied compared to the prior process of check disbursements. But there's 72 community college districts. I don't speak for the CSUs, and so there certainly isn't a one-size-fits-all policy. In some respects, this is a step in that direction.
And let me go ahead.
One final, Mr. Chair. Are you at all concerned that if this bill passes and gets to the floor and passes, that the interest in financial institutions, interest in supplying these debit cards to students will in essence dry up, and the debit cards will not be provided to students, and you will be required as community colleges, or your constituents will be required to issue financial aid in the form of checks?
Sure. And I recognize that there's some differing opinions in regards to some of the language in the bill, and I'm certainly not an attorney, but, as we reviewed this bill, our boards felt that it was a step in the direction of providing a uniform policy, and we decided that was in the best interest of students, recognized that there was some concerns about some of the practices, and, supported it accordingly.
Thank you for your patience.
And let me just follow up to Senator Roth's comment. Students, I believe, have the option of direct deposit as well. You can have those go directly deposit into your checking account. Now, with the Calderon bill, it's another bill that's moving to the legislative body, will essentially, and I quote here, shall provide that the direct deposit within funds be available within one business day of the receipt of the funds from financial aid. So that is what the Calderon bill will do. But you do have the ability to go direct deposit as well. And I suspect, Senator Roth, that I'm not an expert in this area, but the fact that the institutions enter these contracts, I imagine it's for a lot of other services, financial services within the university. It's probably a package deal is what I suspect, but I'm not an expert in this area. Others in support?
Good afternoon, committee members, Chairperson Correa. My name is Roscoe Kiyangyang. I'm a student from UC Berkeley, also a student at Napa Valley College, and also serve under Board of Trustees as a student trustee. As echoed earlier by the representative from the Community College League of California, as well as the bill's main author, Mr. Frazier, I strongly urge that you support this bill. Thank you.
Hello, I'm Tim Marvin, again with Consumers Union, the advocacy arm of Consumer Reports Magazine, and we are in support of the bill. Thank you.
Thank you.
This is Aaron Greenspan again with Think Computer Corporation. I'm in support of the bill, having just read it, and I also would like to make the point that this bill is very much related to AB 786, because we just heard a conversation about why colleges...
Stick to your comments on this bill.
I will do that. Colleges are forced to enter into these contracts with lots of fees for students, and there aren't a lot of choices for those colleges. The debit cards are being made by basically two companies, Visa or MasterCard. And as a company that would love to enter this market but cannot, there's not a whole lot we can do to undercut the prices. If we were able to get a license to hold on to money and provide debit services through mobile payments, which are instantaneous and effectively free and have no delays and no postage costs for universities and no other administrative costs, I think students would benefit quite a bit more, and so would the state, by reducing its administrative costs and increasing financial aid. So there is definitely a link between the ability of money transmitters to provide services like this to students at lower fees and the monopoly that the Money Transmission Act grants to banks, which continue charging fees not just to students, but to all kinds of consumers in the California economy.
Thank you. Senator Wesley, did you have a comment?
Mr. Chair, I'm going to wait till the public comment part of it is finished.
You mean the conclusion? Very good. Others in support? Opposition?
Mr. Chair, I just want to answer your question that you asked me earlier. There is a $25 fee to transfer funds from one account to another.
Per transaction?
Per transaction.
But in one transaction, you take all your money out and put it in your bank account. But actually, you don't need to do that if you have direct deposits. You could just directly deposit the money to your checking account and circumvent the whole process.
Correct. However, you would be waiting an additional week, 2 weeks, and sometimes students need their money as soon as possible.
After the Calderon bill, you won't have to wait for more than a few hours. Opposition.
Afternoon, Mr. Chair, members. Alex Alanis with the California Bankers Association. You're having a letter passed out to you that I'll address in a minute, but I think it's important that we clarify a few misnomers that were stated here today. Under the Card Act of 2009, because the issue of dormancy fees was actually raised here, a card issuer is prohibited from charging any dormancy fee on a card until the 13th month after any kind of activity has occurred. So it is virtually impossible to have a dormancy fee charged to it, because every semester or every quarter an activity is taking place on that card, thereby resetting the clock on that, any kind of dormancy fee that actually would occur. That's assuming that no other activity exists with respect to whether it's an ATM transaction, a point-of-sale transaction, or any kind of a transaction in which money is moved from the card. So I think that's important to clarify that such activity does not exist, and if it does, it is in violation of the Card Act of 2009, which that issue is already addressed. With respect to inaccurate PIN fees, that's got to be the newest thing I've ever heard in my entire life. I don't know if anybody's actually ever gone to any kind of ATM and inputted an incorrect PIN and got charged. That's new to me. With respect to overdraft fees on an ATM transaction, that is for everybody. That is for every single card, the one that's in all of our wallets or your purses today. You could be assessed that on a foreign transaction or any kind of one with respect to your own bank. But that is regulated under Regulation E, which implements the Electronic Fund Transfer Act. You're required to sign up for overdraft protection onto an account during account origination, and then each time a transaction or a fee may be occurred, you are then required to opt out if you choose to opt out. So there are many opportunities in which to avoid that fee. That issue is already addressed under the Electronic Fund Transfer Act. The letter that was passed out to you today was dealing with the issue of preemption. So the issue of preemption came up earlier in testimony about whether it was or was not. So we decided to go to someone who actually litigates in this area, not a generalist from Ledge Council. I'm not here to disparage them. They do very good work. But this was not an expert dealing in the issue of the National Bank Act. The law firm of Morrison Forrester has won several cases in the area of the National Bank Act. Their analysis on this is that this bill will be preempted under the National Bank Act. It's pretty clear. With respect to the issue of regulating fees for a national bank runs counter to the National Bank Act, and several court cases back that, especially under the Barnett Bank case of 1978, which the Dodd-Frank statute of 2010 enshrined the Barnett Bank case, essentially saying that not only are we going to abide by the case, but it is actually law. So now we've dealt with this in the Dodd-Frank bill, in which this bill would be preempted. It's not an issue of whether the bill will be preempted, but when it would be preempted. Because if you are required to abdicate your rights under the federal law, you've established a discriminatory policy in which a national bank cannot participate in the MOU or the contract because they have to abdicate those rights. So a suit then will be there if another bank comes in or another financial institution or entity wins the contract, then they could be sued because they accepted a contract that was discriminatory because it disallowed other entities that have the protection under the National Bank Act to participate to qualify for that contract. We believe that the most reasonable approach is SB 595. You've all considered that bill. It gets to, actually, I think that bill is much stronger than this bill, as is. It deals with the issue of not forcing students to accept a card or open an account as a condition of receiving financial aid, and it allows you, as you mentioned, Mr. Chair, to receive that money on an expedited basis if you wanted to move it to your own account at a bank or credit union. It gives students the choice and the empowerment to decide how they want to receive that. We think to move away from National Bank Act, the Electronic Fund Transfer Act, and numerous different types of lawsuits, especially on the ATM area, which is the city of Santa Monica lost in 2002, and dealing with all those problems that set up litigation problems, to deal with a better issue, which was in SB 595, which this committee did pass. So with that, we would support the chair's amendment, which we think gets to the heart of the disclosure part that the author has stated in the past, and not to deal with something that's going to put the state in a litigation trap.
Others in support.
Opposition, Mr. Chair, opposition to the bill as it's currently drafted in support of the chair's amendments. Cliff Berg here on behalf of Hire One, and I will say, yes, Hire One was founded by students to serve students because the founders of Hire One determined in essence that there was an important need in our financial system for electronic disbursement of funds for students, and that in effect the electronic disbursement of funds is what Hire One does. It is not a bank or a financial institution. It provides the technology for electronic disbursement. I will start with the point that was made earlier by a member of this committee, which is that no school is required to, in essence, provide electronic disbursement of funds for their students. So what they are required to do is if they choose voluntarily to provide electronic disbursement of funds, they're required to offer their students a choice. And the choice that they offer to every student with full disclosure of fees for all the different services is direct deposit into an existing financial institution that the student has a financial relationship with. Paper check sent through the United States mail to a student who chooses the check. Or electronic disbursement via a debit card. That is a clear, informed choice that the student makes as to which of those forms of disbursement they choose. You have heard about fees, and proponents of this bill would say your choice is to be for or against fees. To me, that's a disingenuous approach to this bill. Hire One is opposed to fees, and Hire One has offered the author amendments from the time this bill was in the Assembly that took out a specific list of fees and replaced it with an admonition to the colleges that they should consider limitations on unreasonable fees. Now, why are we in a fight in this committee and taking up all this time about a debate that really doesn't exist? There's no one here who's going to come here and say fees are great and that we want fees. But there is a reality that the cost of electronic disbursement, which is faster, more efficient, and more accurate, and lower cost, has to be paid by somebody. And if someone came in with a bill and said everybody should get debit card services from their bank or financial institution for free, how could we all be against that? Except that someone's got to pay for it. And in reality, these institutions go through an open RFP process and are completely free to negotiate with the providers, whether it's Hire One or anyone else, to limit fees. We've offered language and would support a bill that says schools consider limiting unreasonable fees. So why do we have a problem with the specific fees in this approach in this bill? It's the approach in the bill, and it's the workability, and it's the question of whether it's preempted by federal law. And there's a list of fees in this bill. Well, what's not in that list of fees? Account maintenance fees. Well, what we've discovered is we've dealt with whether it's mortgage loans, consumer credit cards, and a whole host of other areas related to debit credit and loans, is that financial institutions, if they so choose and have to recover their costs, will move from one fee to another fee. So we can put into statute 6 fees and leave off 25 other potential fees, and that's not doing the students any good. Broader language is suggested by the chair, or is offered up by Hire One, to prohibit unreasonable fees would protect students, but we've run into a brick wall, and frankly, I don't know why. What's on the list? Replacement card fees. Well, schools should consider not having replacement card fees. Well, a replacement card fee is there to influence behavior. The behavior is irresponsible behavior in which someone loses 60 cards. Most schools offer a free replacement card. Most state agencies that have gone to debit cards offer a free replacement card. But 5, 10, 20, these issues are complex, and how the various vendors provide a price point on these are complex. And the language in the bill simply is unworkable and will create more problems for the schools and for the students. The chair's language would solve the problem, get to the heart of the concern, and would not create those problems. And before I close, I want to get to the fundamental point that Hire One has always said about debit cards and students, which is that debit cards for students are the first opportunity for many low-income and unbanked students to become participants in the financial system. And for those who are not banked, who are getting a check, they are taking that check to a check casher where they're being charged high fees by the check casher. They're incurring banking fees if they deal with a bank through a standard checking account. There is a whole range of fees for different financial services from different financial institutions. And it's like comparing student checking, debit cards, direct deposit, checks. All those costs are different, and the student has to make an intelligent choice as to what's best for them. and no one's requiring them to take a debit card. So the use of debit cards is a huge opportunity for low-income and unbanked students to become part of the banking system, and they can take those cards to a retailer, to a gas station, to a supermarket, swipe them just the way you use your debit card, and Hire One's not charging fees for those transactions. Retailer might charge a fee. There was a bill dealing with retailer-imposed fees on debit cards at retail locations before the legislature 3 or 4 years ago. But it's an opportunity for low-income students to become banked and not be walking around with a wad of cash in their pocket. So debit cards in themselves, like any technology, are neutral. It's how you use them, what choices you make. Unfortunately, this bill as it's currently presented does not solve the problem and creates more problems, and that should not be the case because there's an easy solution here, and we should not be having this debate, and it's really not a choice between fees or no fees, or you're for fees or you're against fees. A lot of the information you've heard today are stories about, well, this person had some fee somewhere on something. In actuality, the National PIRG report says that there's a potential in this country of higher fees as institutions expand their use of these cards, and calls upon the federal government to enact rules and regulations, which they've done. There's nothing in the report about high fees in California, and I think there is no evidence that those fees actually exist in any large amount.
Thank you. Others in opposition, please.
Catherine Pettibone, the Civil Justice Association of California. We have an opposal list amendment related to the language on mandatory arbitration. We're very supportive of that, especially right now, is getting a civil case through court is going to take years and years and years. We are really supportive of the amendments offered that can have colleges consider how disputes are resolved. We're hopeful that that would actually maybe expand the universe. Students shouldn't necessarily have to go anywhere. We're hopeful that they will create administrative proceedings on campuses where students don't have to go externally, and then only if those things are resolved, then maybe be forced to go to arbitration or court or wherever. But very supportive of the amendments and would remove our opposition on that basis.
Others in opposition. Questions from the committee? Yeah, I'm recognizing. Go ahead, Mr. Wesson.
You know, I think here we're really dealing with a broader issue. And I kind of want to raise that because we were talking about litigation. And yes, I agree that if the state came in and compelled the colleges from doing anything different and saying you can't do this and pass a law, that triggers the litigation. But not if we ask the colleges to go through a process of negotiating better agreements. And I think that the fundamental issue is that colleges have been going through a process of trying to save money. And while I was in college, I had all the benefits of going to financial aid office and getting my check, and they would give me a check directly, and I would go to my bank account and deposit it. And under this program, oftentimes students are not necessarily given the option because colleges are saying, instead of having a person at an office, we'll just outsource our financial aid services through this program and gain savings through that. And we don't really know, as the stewards of the public funds here, we don't really know to what extent these colleges are saving money within their departments and to what extent they're passing those savings onto the users of the financial aid program. So that the people that most need this money to get through college are now being charged for the services that they're being given by giving this financial aid money. And right now, what we don't know in this state is how much our colleges are saving and outsourcing these funds. And number two, we don't know what the total amount of in fees and surcharges and all the charges that are being given to these students, sometimes involuntarily, sometimes voluntarily. We have some colleges that are offering the services voluntarily and students are choosing to opt in. I don't think this bill is directed at them because a lot of those colleges are already offering free subscription, free transactions for a certain amount. This bill would not really hurt them. And to say that these programs are not going to be offered to those students because this bill passes is ridiculous, because we already have plenty of examples in California where colleges are negotiating great deals for their students and saving money and saving them money and giving them a more convenient program. So it can be done. Nobody is suing anybody. There's no lawsuits. So this bill, if administered correctly, would not compel lawsuits. So in that regard, what the bill doesn't do, it doesn't really understand, it doesn't really identify something that's within our fiduciary responsibility, and that's to assess how much these students are being required to pay fees that they're not necessarily aware of in many instances, that are eroding our financial aid programs. Under a schedule of $1.7 billion, and if you take that by the average amount of awards, and if students only paid a $125 fee to cash that check, we're still talking about $10 million reduction in our financial aid program. $10 million is a significant amount of money that could put a lot of kids through college. And that's something that we should, in looking at this issue, that needs to be assessed. I agree with the chair that the amendments create a lot more clarity to what we're trying to accomplish. The amendments are great, but some of the language is stricken from the bill. Kind of takes away the responsibility from the universities to go out there and negotiate the best deals for the students, and to really put an emphasis on fees, number one, and number two, on accounting, on a yearly reporting, maybe getting these financial institutions that agreed to work with colleges to report. I mean, what is the fiscal impact of these agreements with the students? We want to know what they're being charged collectively, the performance of these programs. I mean, I'm not one of those proponents. I know I've heard a lot of stories about people growing up where they take their kid and throw him into the pool and say, okay, swim. And if he doesn't sink and he swims, he'll learn how to swim. And in essence, that's kind of the policy that we're taking currently with our students in our schools. You know, the best way you can learn by how to manage your finances is by getting ripped off. And this bill, with the amendments, gets us to a much better place, Mr. Chair. But I think there's more work to be done. And I think that I think this is a very important issue. I think this is a very important bill. I would like to see the bill advance. I'm going to support it. You know, in its current form, I don't support it. I support some of the bill. I support some of the amendments. I think the amendments as a whole are great. I'd like to work on putting the onus a little bit on the institutions themselves, because they are saving money by outsourcing these services. And that's something that needs to be made very clear. Number two, they have a lot of power to negotiate great arrangements. Just like we have universities that have developed great programs. We want to somehow encourage colleges to use the best practices and to go to those providers that offer the best. You know, it's not just a function of how much we're going to save you. It's a function of how much we're going to save the student. And I'd like to put the emphasis in the language to really to put the emphasis on saving students money. We talked about how there was some testimony about inactivity fees not being possible. Well, they're very possible. They're actually being reported by credit cards, $10 per month, inactivity month after six.
Credit cards or debit cards?
On the debit cards.
Thank you.
On the check cards. $50 overdraft fee is higher than a banking institution. $29 to $38 for overdrawing with a pre-scheduled payment. Again, higher than a banking institution. I think we can do better. I think we can direct our campuses to have a better approach at how they accomplish this. Not just about savings within this institution. They need to put more of an emphasis on savings for the students and giving them a more flexible and better program. And I agree with the language that it's got to be done institution by institution because it's hard to really assess. You know, we have some campuses located in rural areas that don't necessarily have immediate access to financial institutions, and that can get very tricky if we create kind of a framework that may make sense for one university but not another. I understand that some have more resources than others, so giving them some flexibility to accomplish that locally through their boards, but strengthening the language to ensure that this is done. And I feel that if it's done in partnership with the Calderon bill, this legislature this year can work on something very significant to help save the students of financial aid millions of dollars in the coming year. And I think this is worthy of our efforts.
Mr. Wessel, let me tell you that you bring up an interesting point, which is putting the, where does the buck stop? Is it that financial aid office? Is that president or chancellor's office? I don't think so. I'll tell you where the buck stops. It stops with us. Because over the last few years, we have cut higher education every year, which essentially has forced those educational institutions to figure out how to make payroll, so to speak, how to keep those campuses open, how to increase enrollment, how to keep those classes there. And I suspect, again, according, in connection with Mr. Wesso's comments, that these institutions are looking at ways to how to maybe push the cost to the students, but save through other financial transactions that they do. I think it's a bigger financial package that these folks probably get from these banks. Ultimately, again, let me restate that I think that the author and I have the same goals in mind. The question is getting there. And Mr. Wesso, I was listening to you carefully. You want to give the locals flexibility, but not that much. Is that correct?
Absolutely.
Okay.
But flexibility in the, because we have very clear language that they have to have so many ATMs, so many banking institutions. I mean, that can get very difficult to ensure that these banking institutions are sited on campus. I would like to make the, get them to do that, but that may also come with a cost that's.
And let me just finally say that as the bill was being presented and debated, I thought about another issue that usually goes to this area, which is payday loans. Debit cards are not a credit card. Do you know what that means, students? How many here, 18 years old, have credit? How many of you here are building your credit as students? If you use a debit card, that does not build your credit. If you use a credit card, that does build your credit. The reason people use payday loans is because they don't have credit. So, I'd love to pass a law that says no more debit cards, go use your credit cards, and they pay out of your bank account so you can build your credit for the future. So, young man, you said earlier you want to trust. Again, don't trust. Figure out what's in your best interest. Anyway, Mr. Roth, you had a question, and then Mr. Hill.
Thank you, Mr. Chair. I normally just ask questions and try to refrain from making comments, and that sort of prolongs the proceeding. But first I want to say thank you, and my hat's off to the author. You've obviously taken on something that is not without controversy, and you've undoubtedly put up with a lot trying to move this bill along. I am struck by the fact that we have educational institutions here before us speaking in favor of this bill, talking about the fact that it's the right thing to do. And I guess if that's the case, I'm just baffled as to why it hasn't been done before in their contract negotiations, and why they're here talking up a bill when, in fact, they could have negotiated these very provisions, I assume, in the contracts that they put in place for the students. I'm clearly not interested in depriving students of the money necessary to fund an education. We've certainly made that about as expensive as you can in the state of California, and I agree with those who are here who say they need every dime that they receive in financial aid to make it through the process, and we should try to make sure that they get that. I am in terms of my view, a proponent of local control. And some of the speakers today mentioned the fact that this was a bill that simply asked the districts to implement best practices, but perhaps I'm reading it incorrectly, but as I read through certainly the bill and the analysis, it requires the Board of Governors of this or that to adopt policies. It requires that the policies ensure certain things to and include that the students incur no cost to open an account or initially receive cards. And I'm not sure how financially viable that is, and I'm concerned about the fact that we may have a situation if these debit cards are in fact viable and necessary in terms of students, that we create a situation where no one provides them, where there's no economic incentive to ensure that students receive cards. If in fact students have an opportunity to opt in or opt out, how quickly do educational institutions get the financial aid checks to students and let the students take the checks and bank them if they can bank them or cash them if they can cash them? So I've got some concerns with respect to this legislation, although, again, I commend Assemblyman Frazier for bringing this forward. Thank you.
Mr. Hill. Okay, Bill.
You know, it's kind of an emotional issue for me, coming from a family of 10 kids, and myself and my brothers and sisters, most of which were on financial aid of some sort, going through college, working and getting financial aid. And when I see the students today that have to get huge loans because we have to raise tuition to make our colleges work right. The last few years, the tuition has doubled and tripled, and so I review this whole thing in the context of what society is right now. We don't have a free education anymore. It's requires students to put debt on themselves, and most students have debt on themselves when they leave higher education and are looking for a job. They're already in debt. That, of course, makes them make decisions about their lives that are influenced by that heavy debt. So I kind of look at it from that standpoint, and I applaud the Assemblyman for dealing with this very complex issue. It seems to me that generally, Mr. Chairman, I'll just kind of, I think I see where we're going. We're going to be working on this. I would like to find some way, and maybe, because I'll just say this. I wish this went through the Assembly Banking Committee, so we had like a little bit of more of a clear, I don't know why it didn't. Mr. Chairman, if you could, if other banking issues don't go through the other house's committee, it seems like.
Are you asking me a question, or is that a comment?
I think I'm glad it went through our banking committee, but just the procedure, if there's something that's a financial issue that doesn't go through the, having been in the other house for 6 years.
This has been a bill that's been double referred. It went through education, and then it came to our committee. So
yeah, in our house, but
yes,
in the other house, I understand it didn't go through their banking committee, and so I was kind of curious about why that happened. But my basic position is this, coming from that bigger context. There's a lot of public deposits out there in banks, and we have a relationship in the government with banks, and we have this relationship with universities and colleges where we're funding them, and it seems to me that using the power of our purchasing power, we ought to be able to negotiate some kind of agreement that especially students that are of limited means are going to get some kind of limit on their fees. It seems like I don't understand why the situation exists where negotiations take place between a college and a bank, and that isn't the first priority. That isn't the first priority. It should be the first priority. to make sure that the students don't have to pay out money. I know at the schools, in my district, I have 4 community colleges in the great San Jose State University. Fresno State's a good school too, to say that. And I was appalled that young man, he broke my heart when he said how much fees he was being charged. It was unconscionable. And I'd like to do something about that. And I think, Mr. Frazier, you have a bill that's trying to do something about that. So it seems to me that getting a solid opinion of how we can encourage or incite negotiations and influence negotiations that will result in the limitation and reduction of extraordinary fees on our students is a very important policy issue. Okay? Just like that. I just want to say that. I don't know if everybody agrees with that, but our students should have an opportunity not to be charged a lot of money for their services, especially if we have large governmental deposits in these banks, and we allow the banks to have facilities on the public property of the colleges. So I think there's a way that we can establish some laws. I think financial literacy is important. We have to have the banks be encouraging financial literacy. That ought to be another goal. Financial literacy, and so they can avoid charging the fees because the students don't, do the things that cause in a normal way for them to be charged fees. So that I think that is part of the process we should have. It's very important. When I chaired the Board of Supervisors in Santa Clara County, we had banks that came to us, and then all of a sudden they said, well, we're going to charge you fees for the debit cards that you gave to the CalWorks recipients and your food stamps. These are destitute people that had a very limited amount of money. And then, so I said, let's have a meeting with them. So we had a meeting with them. They said, well, we're going to charge you for each transaction $6. I said, we only give them $600 a month. And they said, well, that's what we want to do. And I said, well, can we put, how much deposits do we have in this bank? It was like $2.5 billion of deposits. And I said, can we put on the agenda that we're going to transfer these deposits? And within a week, we got our fees reduced. I think down almost to nothing. And then I said, how about us getting some money back from them for putting our money in their bank? So it seems like getting the business of the students and looking at these as future leaders in our society, that's in the bank's interest to keep them as customers, because they will be good customers as they get their education. And so, Mr. Frazier, I'd like you to work with the chairman. Ben Wessel has his opinions, Senator. I agree with the philosophy of the Senator Wessel. I think that's important that we give the colleges in terms of leverage to get a lower fee level and then leverage to negotiate a consumer-friendly arrangement for our students. And I'll say one more thing before I close, because I'm going on too long. I know it's a long day. I don't want the community colleges or the state colleges and universities to collect a lot of money for allowing these facilities on our campuses if it's at the disadvantage of our students. So there's got to be a way of controlling that so they don't get a lot of cash put in their treasury at the disadvantage of our students. And I don't know if that's happening, but I think we ought to have some general guidelines on that too. So
thank you. And let me state to you that earlier in my statements I said that these agreements have to be in the best interest of all the students. So that can be a preamble.
Yes.
That has to be the number one priority.
It's got to be our top priority.
Thank you. Mr. Hill.
Thank you, and I will be extremely brief. First of all, thank you, Mr. Frazier, for the issue is important, and We don't want our students or anyone's students to be taken advantage of. Not that they are, but if the costs are higher than they should be or inappropriate, or if the institutions are making a lot of money off of these arrangements and partnerships, that's not right. And we need to look at it. But, Mr. Chair, thank you. I think the amendments really did go a long way. And I think you went out of your way to try to create and craft something that would work, and it just didn't seem to come together at the time for some reason. But I think they're really, after rereading them and certainly having the time this afternoon in this committee to reread them, they were.
I even understand them more.
I think they really go a long way. So I mean, I certainly cannot support the bill today, but I would hope, in the spirit of what Mr. Hueso was discussing and Mr. Bell, that there's a possibility of maybe coming together and craft something that would work along the lines that you started already. So thank you.
Thank you very much. Mr. Berryhill, sir.
Last but not least.
That's for me, bro.
Oh, that's you. Yeah. Listen, first of all, I want to thank all the kids, all the students that came up here today. I think this is a really good experience about how this whole process works, better or worse. I want to thank the author. You've been very tenacious. You're going to be a very good legislator. And this bill is very, very well intended. Having said that, just hearing all the arguments today, I'm not sure it's fully cooked. I'm very reluctant, I'm not sure I said that or not when we met this morning, but I am very reluctant to get in the middle of this. And so for that reason today, I am going to be laying off. And if it happens to get through, I think this is part of the process for all you students that are up here today. If it does get through, this is going to give us an opportunity to work on a little bit more if it doesn't get through today. I will say that in my experience up here, metal theft being a big one took me 2 years, and it's not the end of the world if some of this stuff goes to a 2-year bill either. So don't lose faith. Having talked with you today and met you before, I know that you're not going to, and that you're going to be around here to keep up this fight. So good job today. I'm not going to be able to support this one way or another today, but I certainly look forward to working with you.
Thank you.
Would you like to close, sir?
Yes, sir. As many of you know, I'm a general contractor by trade, and I don't do the things I don't do well. I hire the electricians, I hire the plumbers, the roofers. But what I do well. But when the students came to us and expressed their displeasure on how they were being treated, this was an idea that we had to bring forward to the Assembly to ask the colleges to use best practices. One of the things that I'm very adamant about is that my tax-paying dollars are used efficiently in the state of California. I don't know that the colleges have trained individuals to negotiate on behalf of the students. I don't know if they even care. I know that it is being farmed out. That's what I do know. And so with this kind of language, today, we're looking for an opportunity to try to protect the students in any way that we can. I'm not saying that all the players are bad. There's many good players out there that are doing the right thing. But what I'm saying is that given the opportunity, Mr. Chair, I'd like to work with you on this and continue the process because I think we're onto something here. And if it does fail, I would ask for reconsideration just on the fact that I think we had a very good opportunity to vet and listen to the students. And I'm very proud that they took their time today, the day before a holiday, to fly up here and demonstrate their support for what they believe in. And so I'm asking for your consideration, if this does fail today, that we work forward and march forward for the kids, the students, for their education.
And let me say that I also sit in Education Committee and actually voted for this bill in Education Committee. And the words of the chairwoman, Carolou, kind of echo in my mind because she told me, she said, I look forward to seeing what you do with this bill in your committee. And I think she understood that this is a very complex issue that goes beyond just us here. You just said you're not sure who negotiates these contracts and what the process is. I think that's probably right. We don't have anybody here that can address that question. Mr. Westwood discussed financial literacy. I talked about payday loans. So there's some interesting things that could be done here. Should this bill move ahead? It moves ahead. If it doesn't, I'd be very interested in talking with the California Student Aid Commission, with this Ms. Lori Newhouse, and some of the others, and really trying to address this from a bigger picture. But ultimately, let's not forget, the folks that cut higher education in the state are in this legislature. And you put those local universities and colleges in a very ugly position. And that's not an excuse, it's just a fact of the matter. And look forward to working with you one way or the other. And I do want to thank my staff because, again, when looking at this bill, I remember Ms. Liu talking to me about the interesting challenges here. With that being said, seeing no further comments, what is the will of the committee? You have a motion.
Move the bill.
A motion by Senator Wesso. Please call the roll.
Motion is due pass to appropriations. Correa?
No.
Correa, no. Berryhill? Bell? Aye. Bell, aye. Calderon? Hill?
No.
Hill, no. Wessel?
Aye.
Wessel, aye. Roth?
No.
Roth, no. Torres? Walters?
That measure has 2 votes. It needs 5 to get out. We're going to put it on call for a little bit. I think most people have left the building, but we'll be calling out to see if they're still here. And again, reconsideration is granted, of course. That's a courtesy we give all of us here to folks presenting bills. But again, I think we need to sit down with folks that are interested in working on this issue and really dig through it to come up with some good public policy. And again, I thank Mr. Frazier for, coming up with some very interesting stuff to work on. And also want to thank all the students for being here today. I'll give you a little secret. I was once a college student, and the only way I got through college was my Cal Grant B and my Pell Grant, and that was the way I survived. So thank you very much, and we will hold the roll open for this one measure that's still on call for a few minutes. Thank you very much.
Thank you, Mr. Chair.
Yes. What's that? Oh, yes. Madam Secretary, lift the calls and the other measures, please. You guys make sure you voted on the other 2 measures. Did Bill, you voted on all of them? We got you down, Jimbo.
We've got 6 votes on. Yes, 6.
Last call, 30 seconds. Let's see. Very well, we're going to announce the final vote totals. Item number 1, AB 786, the measure moves out 6-0. Item number 4, Assembly Bill 1255, that measure has 6 votes, 6-0, bill is out. Final measure, AB 786, that measure has 2 ayes and 2 noes, that measure fails. We notice reconsideration. Seeing no further business for this committee, we are now adjourned. Thank you. Happy 4th of July.